Yes, Mr. Beggs.
My ladies, my lord, I appear with Mr. Derry, King's Counsel, and Miss Hampshire for the Appellant Commissioner. Mr. Baumber and Miss Benethan appear for the Respondent.
Yes.
The first interested party, the College of Policing, is represented by Mr. Rathmell. The second interested party is not represented and sent a letter which you may have
Which we've
seen.
read.
Court, thank you.
So Mr. Knight's not in court? No.
I don't believe so. May I start by quoting the words of Lord Justice Fulford on the 30th of September 2021 when he sentenced former Constable Wayne Cousins to a whole life tariff for the kidnap, rape and murder of Sarah Everard. He said the police are in a unique position which is essentially different from any other public servants. They have powers of coercion and control that are in an exceptional category. And he went on to emphasise the importance of public confidence in the police, so that their powers of detention, arrest and otherwise control of aspects of our lives can only survive with the critical trust reposed by the public in whichever constabulary it is. And it is those unique powers of coercion and control that frame everything we now say. This appeal, now confined to one ground, is in respect of Mrs. Justice Lang's order that ground 3 of the respondent's claim for judicial review, namely that dismissing an officer consequent upon the loss of vetting clearance would be in unlawful frustration of the 2020 conduct regulations.
Yes.
The central question in this appeal is whether and to what extent a decision about whether a police officer can maintain their vetting clearance can properly consider concerns about their conduct that have not resulted in a formal finding of misconduct. And Mrs. Justice Lang held at paragraph 170 of her judgment that this was only permissible in exceptional circumstances, thereby, we respectfully say, wrongly imposing a legal test with a high threshold. We say the consequence of paragraph 170 is virtually to prevent conduct issues that have not been established in proceedings under the conduct regulations being considered at all in vetting reviews.
Is that a product of both paragraphs 170 and 171? Because of the pause analysis, I don't think it's just paragraph 170.
My lady is correct. And we say that the effect of those paragraphs is to strike at the very heart of the efficacy of the police vetting system and its important function in keeping the public safe. We say that the correct position in law is that once a matter has been considered in the misconduct jurisdiction, it may thereafter be considered in vetting considerations and the vetting process. And the findings or the absence of findings in the misconduct process are not binding and should not be binding on the vetting process, but obviously should be considered with care alongside the totality of the material available in the vetting process. Mrs. Justice Lang set out the background to the case at her paragraphs 9 to 43, and helpfully at paragraphs 11 to 27, she set out
I mean, it's commendably clear, I
Very
would say,
clear.
the exposition of the facts and the codes and the policies.
And so the court will see that over a period of just over 2 years, there were a succession of concerns of varying degrees of seriousness, but with one common theme, namely Sergeant Di Maria's disposition and attitude towards women. But there were other matters as well. See, for example, paragraph 26.
Yes.
And none of these matters, in fact, resulted in Sergeant Di Maria being found to have a case to answer for any criminal offence or indeed for any misconduct offence. And in March of 2023, the Commissioner, through his subordinates, decided to review the respondent's vetting, and no challenge was made to that decision, and the respondent was interviewed in April of 2023. That's supplementary bundle 56 for the court's note. And in September of 23, the vetting review manager...
Sorry, he was interviewed when? In 23?
13th of April 2023.
Thank you. Yes.
Supplementary bundle 56. On the 15th of September 2023, the vetting review manager decided that the respondent's vetting clearance, both at management vetting level and at the minimum level, recruitment vetting, RV, should be removed. Conveniently see paragraph 121 at supplementary bundle 56. And Mrs. Justice Lang set out the vetting review manager's decision at her paragraph 35.
Yes.
The respondent appealed that decision, and the appeal decision maker, Commander Russell, he came to his view, again set out at 37 to 41 of the judge below's decision. As a consequence of the maintained withdrawal of the respondent's minimum vetting clearance, recruitment vetting, he was referred to gross incompetence proceedings under the Police Performance Regulations 2020, as recorded by the judge below at paragraph 43. And at the time, the authorised professional practice from the College of Policing, dated 2021, had important things to say at paragraph 847, which is in tab 8 of the court's supplementary bundle. In fact, I think I've given you, started off with the incorrect reference. It's in fact tab 9, forgive me.
Tab 9, that's right.
And it's at page 131. And this deals with, at 8.47, deals with the different positions for police staff governed by the Employment Rights Act 96 and police officers whose performance is governed by Performance Regulations 2020. 847.1, where vetting clearance is withdrawn or refused on renewal for existing personnel, a different process will need to be followed for police officers and police staff. If vetting clearance is refused at RV, recruitment vetting, unsupervised access to police assets, including premises, information and systems, cannot be granted. And then there are other considerations for MV, which we needn't be concerned with since RV was removed. For police staff, withdrawing RV clearance may lead to dismissal under section 98 of the ERA. Next paragraph, that does not apply to police officers or specials. Therefore, when clearance is withdrawn and suitable alternative employment cannot be identified, and or the risks cannot be reasonably managed, the force should consider proceedings under the performance regulations. When a police officer's RV clearance is withdrawn, they will be unable to access police information and systems. Unsupervised access to police premises will not be permitted. As a result, the police officer will be unable to perform their role to a satisfactory level. This could therefore amount to gross incompetence, and a third stage meeting should be considered. That's a kind of fast track system.
Yes. It's not entirely intuitive, is it, to treat somebody whose vetting has been withdrawn as being grossly incompetent?
My lady, no, and you saw that Mrs. Justice Lang so found. And so it was that my learned friend's client issued judicial review proceedings challenging the removal of his vetting, and my client stayed the gross incompetence proceedings pending the outcome of the judicial review. As the court knows from paragraph 5 of Mrs. Justice Lang's decision,
those proceedings are still stayed, are they?
Well, we're in a different position now.
Because of the new regulations, you mean?
Exactly so.
Right.
So can I just ask you, in a nutshell, what is going to happen next in this particular case?
Well, we are awaiting the outcome of this ruling, this court.
Yes.
And the 2025 regulations will now govern the process. And I'm going to take the court to those regulations because they're brand new, 14th of May, and they set out an Article 6 compliant procedure which deals with the points that Mrs. Justice Lang found to be deficient in this process.
Yes. So, just to linger on that for a moment longer, if I may, what's in my mind is that the order the judge made was to quash the original decision because the judicial review claim had succeeded on a number of grounds.
Yes.
In this appeal, you originally had 3 grounds, 2 of which have been withdrawn. There's only 1 ground which is still live. But even if you succeed on that ground, what will happen to the judge's order quashing the early decision? It doesn't affect it, does it?
No, because his vetting, in fact, also expired by a fluctuation.
Oh, I see.
So it required a fresh application in any event.
I see.
It may help the court just for context, because it does frame what we say about paragraph 170, if I just very briefly traverse the other grounds that were dealt with below. Ground 1, all set out at paragraph 8 on page 104 of the core bundle, was that the Commissioner had no power to impose a requirement for police officers to hold vetting clearance, and therefore no power to dismiss them for want of vetting clearance. And Mrs. Justice Lang found at 99 to 101 that the Commissioner did have the power to impose a vetting requirement, but did not have the power to dismiss an officer for vetting failure, an anomaly that she said should be resolved by regulations. And of course, I'll come on to this. Ground 2 was that the vetting dismissal process being applied by the Metropolitan Police and indeed every constabulary breached officers' Article 6 rights for various reasons. And Mrs. Justice Lang found at 146 that Di Maria's rights were breached, principally by the failure to consider and determine whether he should be afforded the opportunity to call witnesses or to cross-examine complainants, and secondly, by not giving him legal representation. I will skip ground 3 since that's the focus of today's appeal. Ground 4 was that Parliament had not intended vetting dismissals to be determined under the police performance regulations. That's my lady, the Chief Justice's non-intuitive point a moment ago.
Yep.
And that loss of vetting did not properly, with proper statutory interpretation, come within the meaning of gross incompetence. And for those propositions, see paragraphs 181, 186, and 193 to 196. Ground 5 was a rationality challenge on the facts, which the judge felt it unnecessary to deal with in light of her other findings. And as my Lord Justice Singh has observed, we withdrew 2 of our points, grounds of appeal, in the light of the promulgation of the Police Vetting Regulations 2025, which came into force on the 14th of May.
And are prospective.
My lady, yes, but, and of course, are now being worked through around the country in different constabularies. May I go to paragraph 163?
Yes.
In her ladyship's judgment, just to work through the build-up to her finding at paragraph 170 and following. She said, core bundle 143 at the bottom, as a matter of principle, the statutory misconduct proceedings are the intended and proper legal route for the consideration and determination of allegations of misconduct against police officers. As the defendant rightly accepts, he is required to consider allegations of misconduct through the misconduct procedures, having regard to the legislative provisions in Schedule 3 of the Police Reform Act, essentially public complaints and recordable conduct matters, and Part 3 of the conduct regulations. Might I say hereinafter, there's no material distinction between those 2 regimes that Parliament set up, so we don't need to focus on that. We accept and don't resile from that as a general proposition. At 164, she said the statutory misconduct procedures provide important...
Mr. Beggs, I'm sorry to interrupt you. I'm just trying myself to understand why that should be so, the concession that's made in 163. Because, as I understand it, post-appointment vetting has to be conducted on a temporal basis anyway. There will come a time, in some professions it's I think 5 years, it may be 10 years in this context. But anyway, there comes a time when post-appointment vetting has to be reviewed. Is that right?
It is right.
And if you're doing that exercise, which as I understand it, your submission is fundamentally the exercise you're doing is an evaluation of risk.
Yes.
Why can't you just do that evaluation of risk without any misconduct proceedings at all? Because why can't you just take into account all the information that is available to you and reach a view on whether vetting should be continued or not?
Well, perhaps out with conduct matters you could, but in this case, which we're focusing on, the allegations that led to the removal of vetting were fundamentally conduct matters. And the argument will be that my learned friend took below is that police officers are entitled to the full protections of the conduct regime, which is prosecuted under Part 4 of the 2020 Conduct Regulations, whether or not it's a Police Reform Act or police conduct matter. So the answer is that if a conduct matter is engaged, prima facie, the conduct regulations must be pursued, successfully or otherwise, before you consider those conduct matters in the vetting regime. However, my Lord has our point, which is that the failure, I put those in inverted commas, of the conduct prosecution, we say, does not prevent a vetting withdrawal decision, provided the 2-stage test is appropriately discharged.
I see. I had not understood that to be your position. You say if adverse information gives rise to a conduct issue, the appropriate way to explore it is And first and foremost is to go through the misconduct process, is it?
Yes, but that's also what the vetting regulations require, that there is temporal primacy granted to the conduct regulations. So
Just remind me of that. Where's that set out in the judgment, please?
it's not in the judgment because these regulations were not before Mrs. Justice Lang, but I'm going to come to the vetting rate in some detail.
Okay, all right. Take
But
your own course.
for my lady's note, a regulation 12 of the vetting regulations at Authorities Bundle, page 124, which obliges the withdrawal of vetting assessment to be made, pens that if a withdrawal assessment would prejudice any criminal proceedings or relate to a matter which is to be or may be dealt with under the conduct regs, the performance regulations, or Part 2 of the Police Reform Act. In other words, there is a direction, a signposting conduct first, if conduct is the issue. Because
I'm sorry to labour this. Conceptually, I'm still having difficulty in understanding this, because I can well understand that if a public authority chooses to bring disciplinary proceedings, and so it puts conduct in issue,
yes,
I can well understand the point that's being made. But what I'm not at the moment understanding is why it has to go down that route at all. Why can't it just say, we're not going to discipline you, so we're not going to go into misconduct proceedings at all, but we are reviewing your vetting status, and for various reasons, we have reached the conclusion that you're too great a risk, and so your vetting is going to be withdrawn. Now, the consequence of withdrawal of vetting may be dismissal. But it's not, you're not doing it because you're disciplining someone for having done something at all. You're doing it because they are no longer going to have their vetting continued.
And what if the view is taken that misconduct proceedings would not be successful for whatever reason? An absent witness, a dead witness. But there was adverse information that gave reasonable grounds for concern. So I know we're looking
but at that stage, my lady, sorry to interrupt,
Yes,
but at that stage, the scheme of the vetting regulations would be complied with, and you would then go to the vetting regime, because there would never, the bar in Regulation 12...
It's worth looking at 12.4.
Yes, it would
relates
no
to a
longer
matter
apply.
which is to be or may be dealt with.
Yes.
So the new regulation, let's remind ourselves, this is the new regulation. If something falls within the definition or within the conduct regulations, then you have to pause. Is that right?
Yes, the 15.2, where the vetting authority assesses that the matter could not reasonably lead to vetting clearance being withdrawn, it must consider the... forgive me, that's later on. If we stick with 12,
Yes.
as my lady just said, 12.3, for any period during which the vetting authority considers paragraph 4 applies, no such withdrawal assessment may take place.
And that paragraph applies if a withdrawal assessment would relate to a matter which may be dealt with under the conduct.
Yes, so is to be would mean that the conduct regulations or the Police Reform Act has already been engaged, because there is an indication
Yep.
that a police officer may have breached the standards of professional behaviour, or may be dealt with. It may be at an earlier stage of contemplation, but at that stage you can't proceed with the withdrawal assessment. And my answer to Lord Justice Singh's question as to why that is that otherwise it would frustrate the protections that police officers enjoy under the conduct regulations. It may be a question better directed to my learned friend in the sense that he will definitely say what I have just said, because
Well, I understand that.
he doesn't take away the point.
What I'm having difficulty understanding at the moment is why you accept it.
Well,
but if you do accept it, that's fine.
We do accept it because we accept that if there are conduct matters, they fall to be dealt with, if they can be dealt with, under the fair processes set out under the 2020 regulations, Part 4 to be precise. But of course, Regulation 4.2 of the new vetting regulations does make clear that a vetting authority, this is page 121 of the authorities bundle, is not prevented from considering a matter under Part 3 or 4 of these regulations by virtue of the fact that the matter has been considered or determined. We say that is of assistance to us and instruction to the court because it makes clear, contrary to Mrs. Justice Lang at paras 170 onwards, that the fact that you've been in front of the conduct regime does not create an exceptional only admissibility of conduct matters, because it's expressly stated to the contrary there.
What happens in practice if you have concerns about an officer of a conduct sort that under Regulation 12 will then need to be processed under the conduct regs? What happens to the vetting meanwhile? Is there any form of interim suspension or anything like that to protect the public?
Well, you can, under the conduct regs, you obviously have the power to suspend under Regulation 11.4.
Right.
If the public interest...
Obvious to you, Mr. Beggs, not obvious to us. Regulation 11.4,
No, but
right?
if the, under the conduct regime, if the suspension conditions under Regulation 11.4 of the conduct regulations apply, then the officer can be suspended.
But what if it's not a conduct regulation matter? Well, then is there any power there?
Vetting suspension.
As Mr. Berry reminds me, an equivalent
I heard the stage whisper. It's Regulation 13.
at the bottom of 124 of the authorities.
Could you help me with a definition of what a conduct matter is? Take me to the conduct regulations or wherever I can find a definition. Please.
Yes. I'm very grateful to Mr. Bamber. It's 103 Regulation 4
Thank you very much
application.
indeed. Thank you.
These regulations apply where an allegation comes to the attention of an appropriate authority, that's the discipline authority, which indicates that the conduct of a police officer may amount to misconduct, gross misconduct, or practice requiring improvement.
So the conduct includes, as it were, poor practice.
Well,
Practice requiring improvement.
Well, that's a separate, we can put that to one side for the moment. Misconduct is a breach of the standards of professional behaviour sufficient to justify a written warning.
Or more.
Or more, exactly. So written warning, final written warning, or dismissal without notice, or in some circumstances, reduction in rank.
But I'm just trying to get, to use my Lord's phrase, the position as a matter of principle. I don't think we can ignore practice requiring improvement, because it goes to show how broad the compass is of how far-reaching the regulations are, because they are there to govern not just breach of standards of professional behaviour sufficient to justify a written warning or more. It extends to practice requiring improvement, so it could be timeliness, it could be efficiency,
Yes, the reason I suggested we didn't need to consider PRI is simply because those sort of matters are generally very unlikely to engage vetting considerations. That I say that based on my experience, but I'm not saying that I could exclude the possibility of a PRI matter. If you take it by reference to the facts in this case,
Well, of course, I understand that.
it might be thought that these are matters of rather more substantive than practice requiring improvement. But the two key triggers, misconduct is a breach of the standard. The standards of professional behaviour are set out for the court at 115 of the same bundle.
I'm just going to tell you, Ms. Beggs, I'm defeated by my efforts to use the electronic bundle, which is paginated differently and unbookmarked, so I will go to paper.
Yes, I'm afraid that's what I'm using as well.
Well, okay.
So in the authorities bundle, it's at tab 4, page 115.
Schedule 2.
Schedule 2, my lord, yes.
Yeah. Any particular passage?
No, I was simply answering the question from the Chief Justice. And then gross misconduct is a breach of the standards so serious as to justify dismissal. So it follows that there can be matters which are in potential breach of the standards, for example, being late to work, but which would not justify at an early stage a written warning because they would be dealt with differently as a matter of proportionality. But such matters could be dealt with under practice requiring improvement. Practice requiring improvement is typically intended for matters such as poor report writing, uncivil treatment of members of the public, stuff that can be dealt with by management intervention, not having to escalate to the stage of the conduct regulations. Not having to escalate to formal proceedings, in other words. There is a formal process, I hasten to add. Everything in policing is formalised into regulations. But I don't myself see that PRI is really going to engage with the sort of matters that would justify the withdrawal of vetting. Because vetting is about risk to the public, whereas practice requiring improvement, as the name suggests, is an office that's not performing, for example, not dealing with matters as they ought to, but not requiring the formalisation of a process.
So if it's not PRI and it is conduct at the alleged stage, it goes to investigation under the conduct process, under the new regulations. Just to tidy up the point that I asked you earlier, what do you do in the meanwhile? You make or somebody applies for, there is the possibility of suspension
There is.
under the conduct regulations,
Yes.
which is the safeguard against that officer using his or her vetting.
Yes, if the officer can't be otherwise redeployed or reallocated, and if the public interest so dictates, having regard to all circumstances, then the officer can be suspended pending the investigation.
The power to suspend regulation 11.4.
Which I don't think is...
13.4 I thought we found was regulation 13.
11.4 of the conduct regulations and regulation 13 of the vetting regulations.
Thank you.
And where do just give me the reference for that.
The regulation 13 of the vetting regulations
Yes, please.
is at the bottom of authorities bundle, page 124.
Thank you.
And just for the court's note, the 13.4 of the vetting regulations emulates regulation 11.4 of the conduct regulations. In other words, the default is against suspension unless the suspension conditions are satisfied.
Sorry, that's under the 25 regulations. What was the position before these regulations?
The only basis for suspension would be regulation 11.4 of
Yes.
the police conduct regulations 20. So I forget now who asked the question. There is an ability, therefore, under vetting procedures to suspend, as there is under conduct procedures.
Now there
Now.
is. But, yes.
I think, yeah, exactly.
The absence of a power to suspend in the vetting context before these regulations, does that make the concession recorded in paragraph 163 even more dramatic? Because if it's said you've got to go to, if you don't want to do conduct, you've got vetting, you've got a vetting concern that isn't a conduct concern, or that is a conduct concern, you can't do anything.
Well, typically what forces might do is put people on garden leave or very restricted duties. But now that embarrassment is removed by the presence of Regulation 13 of the vetting regulations, and has never been a problem in relation to conduct because of Regulation 11.4 of the conduct regulations. If I may move on to 164 of Mrs. Justice Lang at 144 of the core bundle, she proceeded to say, moreover, the statutory misconduct procedures provide important procedural safeguards for officers and are intended to comply with the fair hearing requirements of Article 6. Those safeguards should not be circumvented directly or indirectly by the use of more informal vetting procedures. And this point, of course, has now been dealt with by the promulgation of the 2025 police vetting regulations. This led the learned judge to ask the question, how then should
Do you say
allegations...
paragraph 164 is correct as matters stood and pre the 25 regulations? Do you challenge that paragraph?
Well, we lost our attempt to argue that the regime, as we had put it together, was Article 6 compliant. And we lost that because we couldn't demonstrate that the vetting regime...
I understand, but the second sentence?
we don't challenge the observation that if there are conduct matters that come to light, they should be prosecuted in the general sense of that word through the conduct regime.
I thought that your premise really was that conduct and vetting are aimed at different
They are aimed at different matters.
And so I assume that you would be saying that that's sort of mixing apples and pears. The use of vetting procedures is a different exercise with a different purpose. And so it's not a question of circumventing safeguards that apply in the conduct arena.
Well, my lady, we've not come to court to argue that with conduct matters you can go straight to vetting, nor does the...
No. Go on.
Because that is not our purpose, that is not what the vetting regulations say either. Now, but there haven't ever been vetting regulations until 25.
No, I understand that. I mean, I just think it's important that we need to... we're not ruling on the new regulations.
No.
We are ruling on the position as a matter of principle pre those regulations. And I think it's important that we bear that in mind, I think.
Albeit in the context of a now much clearer and Article 6 compliant regime, until anyone challenges that aspect of the vetting regulations. The point of this appeal is that the learned judge below circumscribed the deployment of conduct matters with a legal test of exceptionality, which we say is just wrong in law and inconsistent with the vetting regulations, the Home Office guidance on vetting, the APP on vetting, and the vetting code of practice.
Right, so do you accept the correctness or otherwise, do you say that para 171 is correct? It seems to me that, having listened to your helpful submissions this morning, you're saying that is the right way.
Yes, we accept that where there are conduct matters, then prima facie they are dealt with under the conduct regulations. And when I say dealt with, they go through the conduct regime, and they may or may not succeed if success is defined as a sanction or dismissal. But that's not the end of the matter, because at the end of the conduct process, it is permissible, for the reasons my lady just gave a moment ago, different purposes are served by the vetting regime, namely the protection of the public by a vetting decision. So it is perfectly possible, for example, as happened in the Victor decision in front of Mr. Justice Eyre, that an officer, in that case a probationer officer, was found to have breached the standards, meriting a final written warning, and thereafter the force subjected her to a vetting review and withdrew her vetting. But that's for the very reason that the conduct regime and the vetting regime serve separate, albeit overlapping, purposes. I'm not suggesting that there is no connection between their purposes, but they are separate. Conduct regime requires proof on admissible evidence of specific allegations, whereas vetting is a more general assessment, multifactorial assessment of risk to the public.
Ms Beggs, just to clarify, really, but it would help, I think, the court to just to really focus on which bits of 170 and 171. I had picked up from your skeleton that 171 was challenged.
It is.
Right.
Which bits? And what is challenged? Based on,
The notion of I understood from your skeleton that you were challenging the idea that you had to pause your vetting process to put the conduct allegation through the conduct process.
Well, on the facts of this case, if one focuses on the, if I can call it the Tesco allegations, in that situation there wouldn't be any requirement on the facts of this case to pause, because those are admitted matters. Sex in a public place, in the vehicle, in a Tesco car park on 2 separate occasions, has been admitted and therefore could be dealt with. By way of an example, to my Lord Justice Singh's point, could be dealt with under vetting, because the protections of the conduct regime on admitted matters become odious if you've admitted it.
But I asked you whether or not you challenged 171, and you said you did not challenge 171. You accept that it is normal to pause if it's a conduct matter that needs to be.
Yes, the ordinary position will be that if there are conduct matters to be assessed, one would proceed down the conduct regime as a general proposition.
Why?
Why?
Because if at the end of the day, the vetting exercise is a completely different exercise, and your fundamental submission is that it's not somehow bound by the conclusions of the misconduct proceedings, because you're entitled to take into account all relevant information, even allegations which have not been proved on a balance of probabilities, for example. Then why waste everyone's time pausing for that process to be gone through, where the fundamental exercise you're engaged in is the vetting exercise?
My Lord, will the court just give me 1 moment, since there's a fundamental point being raised?
Yes. Would you like us to rise for 5 minutes?
I don't think that's necessary,
Oh, all right, good.
but I'm grateful for the offer. It's,
could lead you, not just because the 25 regulations are there to have done this, misconduct. This is what maybe those cases. Whether it's challenging,
I'm very grateful for the time. We are not advocating the position that you can, I don't mean this pejoratively, circumnavigate the conduct regime. We, for reasons that I will develop at a little greater length, by looking at not just the vetting regs, but also the Home Office guidance, which seems to us to indicate that one, as it were, exhausts the conduct regime first before moving to the vetting considerations. So I hope our position is clear, even if the court thinks we are taking an unduly...
But I think, okay, so we will certainly let you develop the case and stop asking you questions. But just for the note, do you challenge paragraph 171 in total, in part, or not at all?
My lady, the ordinary position will be that if there are conduct matters as properly described, the ordinary position will be that they go to the conduct regime. But as I mentioned, in this case...
I understand, but so you do not challenge paragraph 171?
You don't challenge the principle there, do you?
Not the principle.
You just say there were matters here that weren't properly characterised as conduct matters because they weren't.
Correct.
Is that right?
Yes. And that's the... It's not the consent issue, it's the fact of having sex in a public place, in a vehicle.
But this as we all can see, the judge here is dealing with matters of principle. She goes on to deal with the facts at 172 and onwards. But these are matters of high-level principle, and you do not challenge the high-level principle identified in para 171.
No, and we say that principle is now consistent with the vetting regime.
That's certainly what the regulations now say.
Yes, and we do challenge the judge's analysis at 172 to 174.
Understood.
That's to do with the specific facts of this case.
It is,
Right.
exactly.
Can I just see how this fits into the overall structure of the appeal? Is your fundamental challenge on this appeal to the point of principle in paragraph 170?
It is. That is the fundamental challenge, that the learned judge below erected a legal test of exceptionality before you could take into account conduct matters.
Yeah. So that at least we have understood correctly. You are still maintaining that is where the judge has erred in law.
My lord, yes.
Yeah.
Mr. Begg, one
No.
One follow-up
All
from
I was going to
that.
say is that I probably misunderstood, and I don't want to rehearse old ground again, but I'm afraid I had analysed the judge's reasoning that her analysis of principle at 171 is closely related to her analysis at 170. And the reason why she concludes that you usually have to pause the vetting process and refer the new allegation for the misconduct proceedings to be exhausted is because of what she has said at 170. But I may have misunderstood, and you've made it very clear you're not challenging 171 as a matter of principle, so I can probably forget about that.
Thank you.
Right.
Before we move on, I had understood the attack to 170 to be broader merely than the notion of the exceptionality caveat. And I wanted just to check I'd understood the next sentence about the misconduct proceedings being respected and accorded primacy, which again I'd understood from your skeleton to be challenged. But I think what you say now is certainly they do have temporal primacy. And in a sense, they do have primacy. There's nothing wrong with the conduct proceedings going first. You would say that's the right solution.
Correct.
So that's not in challenge either. So this is narrowly a challenge to the exceptionality caveat.
My lady, yes, because Para 170 has the effect, if one looks at the second part of it, the learned judge below said, so in this case, the vetting officers should have made their assessment on the basis that in the light of the findings of no case to answer, there were no reasonable grounds for suspecting. In other words, what she is excluding is any consideration of conduct matters, effectively, unless proven. And in this situation, that would disable the vetting personnel from taking into account all the material that the learned judge so carefully and helpfully set out, as I took you to earlier, in her judgment from paragraphs 11 onwards. And of course, the vetting test, which is a two-stage test, requires first an analysis of whether there are reasonable grounds to suspect various matters, and if there are reasonable grounds for suspicion, a low threshold, then the second part of the test is whether it's appropriate to remove vetting, having regard to all circumstances.
Yeah, understood.
And on a proportionate basis.
I think it is very helpful for us, I'm afraid, to ask so many questions. But I do want to come back to that sentence. The determination in the misconduct proceedings should be respected and accorded primacy. Now, I understand that you accept temporal primacy, but going back to my Lord's point about how I understood the argument to be based on different purposes, even if overlapping, that there is no notion of determination in misconduct proceedings having primacy. It's a different exercise. Is that your case, or are you content with that sentence, both in terms of temporal and substantive primacy?
Temporal, yes. Substantive, no.
Good, okay. Understood.
And may I, so that we can cut to the chase, say why we say that the temporal primacy, which is governed by the vetting regulations, we do not quibble with, but primacy shouldn't be given the meaning that if you have failed to convict, I can use that term, an officer of gross misconduct or any misconduct, that's the end of consideration of those underlying facts. And the reason, in short form, is that the police misconduct regime tests narrowly defined allegations of misconduct said to be in breach of one of the standards in Schedule 2 conduct regulations. It has to do so to the civil standard of the balance of probabilities, and it has to do so against admissible evidence, whereas the vetting process is a multifactorial assessment of risk posed by that officer arising from matters much broader than narrow conduct allegations. The standard, the gateway standard, is reasonable grounds for suspicion, which is well established as a low threshold. And there may be a wide range of evidence, as indeed in this very case, and some of which is intelligence, some of which is perhaps more than intelligence. It may include admissions, much of which may not be admissible in misconduct proceedings. So that's the answer to why we say yes, temporal primacy, but no, not substantive primacy. They are separate regimes designed to fulfill separate purposes. I perhaps also ought to add that the conduct regime is principally designed, as all the case law says from Bolton and the Law Society onwards, is principally designed to maintain public confidence in police service and the reputation of the service. So it also fulfills that public-facing purpose, so that the public can understand that if they make a complaint or there is a conduct matter against an officer, it is publicly dealt with. Whereas vetting has, as I've indicated, a wider and different purpose, albeit overlapping. They're all part of a regime designed to protect the reputation of the service and the integrity of the service.
And preserve public confidence.
Preservation of public confidence is the overriding objective of both regimes, ultimately.
I see.
It may, subject to the court's approval, now be worth looking at the new regulations, since they will provide much needed context to the court's assessment of whether paragraph 170 was correctly determined.
Why do they do that?
Well, because it may give the court the reassurance that the new system is a fair Article 6 compliant.
Well, I'm sorry, Mr. Beggs.
If that's not necessary,
No, I'm not saying you shouldn't go to
No.
it. Can I just ask you this? Surely the question on an appeal for this court is, did the judge get it wrong? Now, the judge didn't have the 2025 regulations in front of her, so why does it help to demonstrate that she got her analysis at 170 wrong? As I said, I'm not going to stop you. I'd like to see the 2025 regulations, but I'm not sure it deals with showing that the analysis there is wrong.
well, in that case, let me simply go through it at some pace, just so that the court has the structure. But if the court would prefer me not to,
No, we've looked at them briefly, so take it at pace. We looked at regulations 11, or, didn't we, or 12? We looked at
yes,
12.
I think one starts with Regulation 4. Which simply provides that parts 3 and 4 of these regulations apply where information which indicates that a police officer may no longer be suitable to hold vetting clearance defined as a matter comes to the attention of a vetting authority. And then importantly, for our paragraph 170 arguments, a vetting authority is not prevented from considering a matter under parts 3 or 4 by virtue of the fact that the matter has been considered or determined under the conduct regime. Paragraph 50, Regulation 15, on page 126 of the core bundle, flows from the application Regulation 4. The vetting authority must assess whether the matter could reasonably lead to vetting clearance being withdrawn. That's the vetting severity assessment. And then subject to Regulation 12 at paragraph 4, where the vetting authority assesses that the matter could reasonably lead to vetting clearance,
Did not reasonably lead.
there must be then a withdrawal assessment. And subject to Regulation 12, we looked at that. Regulation 12.3 is the temporal primacy granted to the conduct regime. For any period during which the vetting authority considers paragraph 4 applies, no such withdrawal assessment may take place. And that applies if there would be prejudice to criminal proceedings or relate to a matter which is to be or may be dealt with under, amongst other things, the conduct regulations. If the vetting withdrawal assessment is to take place, Reg 16 is the appointment of the assessor. The withdrawal assessment is provided for by Reg 17, including the potential of an interview. Regulation 18 provides for a notice to be provided. 19 allows the officer to make representations. Regulation 20 provides for an interview. And then one gets to Regulation 23, which is the report of the withdrawal assessment. And that report must accurately summarise the evidence, attach any relevant documents, and give the opinion of the assessor as to whether the vetting clearance should be withdrawn. And then the vetting authority decides what the disposition should be in Regulation 24, which includes withdrawing vetting or downgrading vetting or imposing conditions by way of mitigation of risk. And so the only purpose of taking you through that regime is to demonstrate that the Home Office has now answered Mrs. Justice Lang's Article 6 concerns. Indeed, as the court will see, the officer, if his or her vetting clearance is withdrawn, which of course leads to dismissal without notice, that's the consequence, they have the right to an appeal, see Regulations 26 onwards.
All of this just makes me wonder again, why this is a self-contained regime with Article 6 safeguards, you say, all in the context of vetting and vetting only. If you're right that it's conduct first, and the conduct regulations and the processes attached to that are all gone through, then you go through it all again with vetting, potentially.
Yes. And I should have concluded by saying that ultimately, if the officer isn't satisfied with the internal appeal, they have the right to go to a police appeals tribunal, see Regulation 31, which is the same destination as performance regulations or conduct regulations. The next important document to take you to is the Home Office guidance on those regulations, and that's in the supplementary bundle at tab 13.
And we need this because?
Well, because it informs you as to whether paragraph 170 is correct.
Then the judge didn't have this in front of him.
My Lord, no.
Right.
It informs the consideration by this court of paragraph 170 for the reasons I hope to demonstrate again rapidly. Paragraph 1.1 on page 242, the guidance is issued by the Home Secretary and relates to processes and procedures for handling matters subject to police vetting, withdrawal assessments and relevant appeal processes and so forth. And at the end of that paragraph, and clarifies the relationship between vetting withdrawals and other relevant regimes such as criminal and conduct. And then at 1.3, this guidance includes reference to the standards of professional behaviour that apply to all police officers in England and Wales and sets out the relationship between the vetting withdrawal assessment process and the standards of professional behaviour, including consideration of the risk posed by an officer should they have breached those standards and how that may impact their ability to maintain vetting clearance. And then at 1.33 at page 247 of this supplementary bundle, this deals with the standards of professional behaviour and the vetting regulations. These standards are relevant in vetting matters because all members of policing are expected to act with the highest levels of integrity. If an officer doesn't uphold these standards, they may pose a risk that makes them unsuitable to hold vetting clearance. When considering the suitability of an officer to hold or maintain vetting, the vetting authority and the assessor should consider whether the individual has previously behaved in a manner inconsistent with the standards. We say that's informative of the errors in paragraph 170 of the learned judge below. Any such breaches should receive scrutiny during the withdrawal assessment. However, scrutiny should be reasonable and proportionate, taking into account, for example, the severity of the breach, the length of time passed since the breach, and the relevance of the breach to the vetting matter at hand. It's important to note that breaches of the standards of professional behaviour, though potentially relevant to vetting, are first and foremost a conduct issue. As such, if any vetting inquiries identify a matter previously unknown or untested by the conduct process, which indicates that the standards of professional behaviour or conditions of service have been breached, then the vetting authority should notify the appropriate authority.
Sorry, who's the appropriate authority in that context?
The appropriate authority in that context is the appropriate discipline authority. And then if I could proceed to paragraph 1.46 and 1.47, which again bears directly on this court's consideration of the accuracy or otherwise of paragraph 170 of the judge below. 146 at page 251 of the supplementary bundle, officers may become subject to the vetting regulations after related criminal performance or conduct proceedings have concluded, or as a result of findings from criminal performance or conduct proceedings leading to a vetting review under the vetting APP, which of course I will take the court to. In some cases, the findings or outcome of those proceedings, or the evidence or information gathered in the course of those proceedings, may trigger a vetting withdrawal assessment following a vetting severity assessment, or where a vetting withdrawal assessment has already been triggered, form part of the force's consideration for the matter. And this next paragraph, 147, we say accurately expresses the law.
This is like marking your own homework. I mean, this has been produced, this is Home Office guidance, and...
Come out after the judgment, yes.
Yes. So just intellectually help us, Mr. Beggs. How can this inform? I understand forensically, I think you mentioned, you know, this will give you comfort and reassurance. But forensically, how can it inform our decision?
Well,
intellectually.
I would respectfully suggest that this guidance states that which has always, we would say, been the correct analysis of the vetting considerations. And so I accept, of course, Mrs. Justice Lang did not have this before her, but we say that 1.47 in particular, which, if I may, I will read, is the correct exposition of the position by contrast with her paragraph 170, which is forces must give appropriate regard to the outcome of such proceedings, though the proceedings criminal performance or conduct. However, any outcomes which state that the matter being considered is unproven, or that the officer is not guilty of having carried out the offence in question, do not preclude forces from assessing whether the officer remains suitable to hold vetting clearance in light of the same matter. So to go back to my lady, the Chief Justice's question, we say that, albeit after Mrs. Justice Lang's decision, correctly expresses the law. For example, it may be that evidence was inadmissible in criminal proceedings, pausing there, that applies equally to misconduct proceedings, recognising, as I do by way of digression, that misconduct proceedings are more liberal in their admission of evidence, but they nonetheless have rules. So going back to this, for it may be that evidence was inadmissible in criminal proceedings that is admissible as part of the vetting withdrawal assessment. The same principle applies where an officer has been found to have no case to answer, which in the misconduct jurisdiction means that on no legitimate construction of the facts could a panel find, the emphasis there being could a panel find. It's a different test from the Crown Prosecution Service's evidential sufficiency test, which connotes realistic prospects of conviction. So the same principle applies where the officer has been found to have no case to answer, or where an investigation has been discontinued for any reason. Vetting authorities will need to consider on a case-by-case basis what weight, if any, to attach to matters that have already been considered as part of criminal or other proceedings, which must include other regulatory proceedings such as conduct, where the vetting withdrawal assessment leads to different conclusions from those reached in criminal, performance or conduct proceedings. The vetting authority should be able to give clear reasons as to why this is appropriate. And what we say is that expresses the law as Mrs. Justice Lang ought to have found it, but plainly did not, at her paragraph 170. We also rely on paragraphs 151 to 152 over leaf, please. There may be occasions where it is the case that the matter identified by the vetting authority could both reasonably lead to vetting clearance being withdrawn and involve an allegation which, if proved, would amount to misconduct, gross misconduct, or practice requiring improvement. Any matters which meet the latter threshold must be handled under the conduct regulations before they can continue to be handled under the vetting regulations. This is why I was indicating earlier that there is temporal primacy granted to the conduct regime. This must lead to a pause in proceedings under the vetting regulations until proceedings under the conduct regulations have concluded. There may also be cases where the unsatisfactory performance or attendance of a police officer is also assessed as a matter which could reasonably lead to withdrawal of vetting. As with conduct matters, these performance matters must be handled separately and under the performance regulations, and vetting proceedings must be suspended in relation to the same matter until it's no longer being dealt with within the performance framework, which the court will see is entirely consistent with regulations 4, 12 and 15 of the police vetting regulations.
I suppose, Mr. Beggs, one scenario that may arise is that there is a pause. As you say, there's temporal primacy given to the conduct proceedings, and that panel concludes that the charges have been proved, including potentially new matters, which is why there's had to be a pause. And I think you would say, is this right, that the vetting process would benefit because it'll be better informed then, but you also submit that it doesn't necessarily work the other way around, that just because things have not been proved doesn't prevent the vetting exercise from properly taking into account matters, but it all depends on the circumstances, what weight, if any, can be given to those matters. Is that right?
It is right, my lord, because, for example, if an officer is found guilty of gross misconduct, and let us just posit that the gross misconduct relates to sexual misbehaviour towards vulnerable members of the public, it is possible that a misconduct panel could deem that a final written warning or reduction in rank was sufficient, but the vetting authority might take a very different view for reasons I don't need to express. That is why the vetting regime, you can also regard it as a fail-safe regime in the public interest to maintain public confidence in policing. Obviously, the objection to removing someone's vetting, if they have only received a final written warning for that example, would be that you're having a second bite at the cherry. But that tension has to be resolved by the vetting regime. And if the vetting authority properly rationalises why, notwithstanding a misconduct panel finding only a final written warning, nonetheless the officer should lose his vetting, the consequence of which is dismissal without notice, then so be it. And of course that officer has, as I've already indicated, an internal appeal and a police appeals tribunal appeal, and of course ultimately a public law right to go to the administrative court. The final, I should, though, when answering my Lord's question, also indicate that there will be circumstances where a misconduct panel, for example, at half-time under a Galbraith submission, finds there's no case to answer. But the reason for that may well be that they have decided, on the facts of that case, not to admit the hearsay statement of, let us say, 2 complainants who haven't turned up, which in vulnerable female cases and or domestic abuse cases, it is, as a matter of public record, not an infrequent situation. That, of course, would require the vetting authority very carefully under stage 2 of the test, because it would surmount stage 1, reasonable grounds for suspicion. Those reasonable grounds would be comprised in the MG11 statements of the complainants. The fact that they didn't turn up to the misconduct panel would mean that the misconduct allegation, if hearsay was not to be admitted on a case-sensitive basis, the misconduct allegation would fail, but it wouldn't and shouldn't, in the public interest, preclude the vetting authority from saying, nonetheless, I am looking at those 2 complainant statements, and I'm looking at a wider range of other matters that would never have achieved admissibility in a misconduct regime, but which I am now entitled to have regard to in the vetting regime. To conclude with the references to the Home Office guidance, I need to take the court briefly to 2.14 and 2.15 at the bottom of page 257. Where an officer has been subject to either criminal or disciplinary proceedings and not being dismissed as a result of either, the vetting authority should, in accordance with the College of Policing's Code of Practice, conduct a review of the officer's vetting clearance. It's important to note that this is not in and of itself a vetting withdrawal assessment, nor does it mean that the officer will be subject to a vetting withdrawal assessment. The aim of this vetting review is to consider the officer's suitability to maintain their current police vetting clearance. If the vetting authority, during the course of the vetting review, assesses that there is a matter which indicates that an officer may no longer be suitable to hold vetting clearance, then they must act in accordance with the vetting regulations. The vetting review will take a holistic view across the entire service of the officer. This will include all factors relevant to assessing the suitability of an individual to hold vetting clearance, such as previous conduct or criminal matters, as well as factors such as positive performance or commendations. There is, I'm afraid, yet further guidance to be derived from this time College of Policing publications. First, the Vetting Code of Practice, which my lords and ladies have at supplementary bundle page 135, and then there is, if I can just, then there is the APP for vetting, authorised professional practice issued by the College of Policing. The 2021 version was in force when Mrs. Justice Lang dealt with the case. That's at the court's tab 9 of the supplementary bundle, and the up-to-date version, May 25, is at tab 12. And it's not in dispute between the parties that chief officers are expected to have regard to the APP in discharging their responsibilities under the vetting code and would need a good reason to depart from it. The purpose of the vetting regime is explained in up-to-date language at 196 of the supplementary bundle, and it's to be found at paragraphs 1.1 and 1.2. Essentially, coming back to the point about public confidence, the highest ethical and professional standards, 1.2, it is essential that the public is confident that police vetting processes are effective. They must be able to trust them to identify those posing a potential risk to others. And so far as post-appointment vetting is concerned, Mrs. Justice Lang acknowledged in her paragraph 55 the importance of that. She said, post-appointment vetting is necessary because, as the APP states at paragraph 841.1, vetting is based on a snapshot in time and an individual's circumstances may change. Pre-appointment vetting may not reveal all risks posed by an applicant, and some risks may only materialise once the officer has taken up their appointment. And then she referred to the triggers for a vetting review, and confining myself to conduct triggers, we identify three. First, upon routine expiry of the vetting clearance, because, as was observed earlier, vetting is only for a limited period, and for the minimum vetting required in the Metropolitan Police, namely recruitment vetting, the renewal period is 10 years. And I don't think that's an issue, so I needn't take my lord and my ladies to the references, they're in our skeleton, to the vetting code and the 2 APPs. The second trigger is adverse information coming to light about the officer or a material change in their circumstances. And we see that from supplementary bundle tab 10 in the vetting code of practice, the statutory code, which deals with this at paragraph 5.7 on page 140. Under the heading adverse or other information, this was the trigger in Sergeant Di Maria's position. Forces may review or renew any clearance before the review or renewal date. They must do so, that is to review, if adverse information comes to light relating to the individual or if there is a material change in an individual's personal circumstances. And 5.9, integrity checks, is to much the same effect. And the court will find the same propositions in the 2021 APP. May I just give you the reference rather than take you to it? It's at 8.48.4, supplementary bundle 133, tab 9. And in the up-to-date vetting APP, it's 7.2.3.B. I'm sorry, it's a 4-digit reference at supplementary bundle 207. So adverse information, material change of circumstances, triggers a vetting review. The third trigger is the completion of misconduct proceedings that do not result in the officer's dismissal. So again, going back to the vetting code at the APP 2021, it's at the bottom of page 134 of the supplementary bundle. So this is what was before Mrs. Justice Lang, 8.50, reviewing vetting clearance following misconduct. Following the conclusion of a misconduct hearing or meeting, meeting is simply where the maximum sanction is a final written warning, where the officer, special constable or member of staff is not dismissed but has been issued with a written warning or a final written warning, a review of vetting clearance should be carried out. The review includes a consideration of the applicant's suitability to maintain the level of clearance held and to continue in the post they occupy. And self-evidently, paragraph 170 conflicts with that as a matter of the purpose of such a review. The vetting code in the very next tab at 141, paragraph 5.10, is to the same effect. Following, and of course this was before Mrs. Justice Lang, following the conclusion of misconduct proceedings that result in a sanction other than dismissal, an individual's vetting clearance will be reviewed. This does not preclude a decision to review a vetting clearance even where no sanction is given, that this review can result in the clearance being granted, granted with conditions, downgraded with or without conditions, or declined. And the up-to-date vetting APP is to be found at supplementary bundle 209, 208, under the heading Reviewing Vetting Clearance Following Misconduct. at the bottom of 208 of the supplementary bundle, as a minimum, a focused vetting review of police personnel's current clearance must be conducted following the conclusion of misconduct proceedings which resulted in any sanction other than dismissal. The focused vetting review must consider the vetting applicant's suitability to maintain their current police vetting clearance and continue in their post. The focused vetting review does not restrict the force vetting manager from requiring a full vetting review or the submission of a new vetting application form where it's considered appropriate, where the force vetting manager determines it justifiable, necessary and proportionate. A review of vetting clearance can be conducted even when no sanction is given. And then at 733, the important words, misconduct proceedings and a subsequent review of vetting clearance are different processes that, although closely related, are distinct. Conduct regulations must take primacy, and a vetting review is not in lieu of misconduct proceedings or a route to subvert the protections afforded through misconduct proceedings. When a misconduct investigation or proceedings have been initiated or are ongoing, any risk posed by police personnel can be effectively managed through restrictions or suspension, so there is no requirement to review vetting during this period. A review of vetting following misconduct must commence following the conclusion of misconduct proceedings which resulted in any sanction other than dismissal. A misconduct allegation may have no case to answer following a misconduct investigation or proceeding. If appropriate, any adverse information highlighted in such cases can be assessed through a focused review. And this continues up to 7.37.
Mr. Beggs, you said that at page 134, 8.50.1 of the 2021 APP on vetting was inconsistent with paragraph 170. And could you just explain, for my benefit, why that is so?
Yes, because the learned judge below, in 170, created the exceptionality test and effectively, in reality, foreclosed the ability of the vetting regime to deal with the officer appropriately under the two-stage test.
It may not matter, but I don't see why that's so. And this says you've got to have a review, following the conclusion where there is misconduct but no dismissal, you have to have a review. Why does 170 preclude that?
Well, because 170 effectively precludes the deployment of the conduct matters, save in exceptional circumstances. The example that Mrs. Justice Lang gave being new evidence. What we say is that both the 2021 APP, the 2023 Code of Practice, and the 2025 APP and Home Office guidance make very clear that the test, the high test that Mrs. Justice Lang applied in 170 is wrong and contrary to the public interest. Because in effect, she has found in the second part of her judgment in para 170, the vetting officers should have made their assessment on the basis that in the light of the findings of no case to answer, there was no reasonable grounds for suspecting that the claimant committed the rapes. And we say that that is not an appropriate test or proper analysis of the state of the evidence. The fact that there is no case to answer doesn't mean irrefutably that there are no matters of concern.
Can I, Mr. Beggs, take you back to page 209, which you showed us a moment ago, which is the 2025 APP?
My Lord, yes, thank you.
And in particular, you read paragraph 7.3.4. Conduct regulations, etc., must take primacy, and a vetting review is not in lieu of misconduct proceedings or a route to subvert the protections afforded through misconduct proceedings. Now, that doesn't confine itself to temporal primacy. And could it be argued that that actually is consistent with and reflects what the judge said at paragraph 170?
My Lord, I would suggest not. It is, although you're quite right, the word temporal is missing before the word primacy. If one looks at the totality of the materials to which I've just directed the court's attention, in other words, in chronological order, the 2021 vetting APP, the vetting code, and the 2025 APP, it seems to us plain that once misconduct proceedings which don't result in dismissal have concluded, that a review of vetting must follow. Indeed, that's what para 7.35 says in the next paragraph. And yes, those sitting behind me are urging me to draw to your attention 7.36. The vetting review should consider the conduct that resulted in the initiation of misconduct proceedings. However, this is in the wider context of the individual's suitability to hold a vetting clearance against the factors outlined in this APP. This is a holistic assessment of all information known, including that considered in prior vetting assessments. All vetting decision rationale should be full, detailed, well-reasoned and proportionate. What we say one can draw from this guidance is that concern about an officer's conduct must be considered under the vetting regime in 4 circumstances. First, where the concern doesn't result in a severity assessment under the conduct regulations at all, but nonetheless constitutes adverse information. Second, where the concern does result in a severity assessment under the conduct regulations. I should add, a severity assessment is an analysis of what the appropriate authority has before them at the time in relation to the evidence and whether this should be misconduct, gross misconduct, or practice requiring improvement. But where the investigation, the conduct investigation, is terminated either by a fresh severity assessment in the light, for example, of new evidence, or by a no case to answer decision. In that situation, once the conduct regulations or the regime stops applying, the concern becomes an adverse information requiring a review, and there is no longer any preclusion by reason of Regulation 12 of the vetting regulations. The third example is where the concern results in misconduct proceedings, but they conclude with no finding of misconduct, and once those proceedings are over, one is left with adverse information, which requires the vetting review, which isn't precluded by Regulation 12 of the vetting regulations. And fourth and finally, the concern results in misconduct proceedings that conclude with a finding of misconduct or gross misconduct, but a sanction short of dismissal. Again, in that situation, there is adverse information and a withdrawal assessment is no longer precluded under Regulation 12 of the Police Vetting Regulations 25. And we invite the court to observe that nowhere in any of the statutory material to which I've just taken you is it said that a concern about an officer's conduct cannot result in the withdrawal of their vetting clearance. It didn't say that in the vetting code or the 2021 APP, and it doesn't say it in the more recent publications, that is to say the vetting regulations, the Home Office guidance on vetting, or the 2025 APP. Indeed, the latter document says at 7.37, a vetting review following misconduct may lead to a withdrawal assessment which can result in vetting clearance being withdrawn. And as the court knows now, the result of clearance being withdrawn is the officer's automatic dismissal. Mrs. Justice Lang's decision on what was then ground 3 had 2 limbs. Limb 1 was whether the first stage of the vetting test could be satisfied by a matter that had been found to have no case to answer, that is to say, the 2 sets of rape allegations. And limb 2 concerned whether the sex in public, which was admitted but hadn't been investigated, could be considered in a vetting review. The former is perhaps more important, and the judge was focused on the first stage of the vetting test. Are there reasonable grounds for suspecting that the applicant is or has been subject to any adverse information? And in 170, Mrs. Justice Lang found that where an allegation has been determined in the misconduct process with no case to answer or nothing proven, and in this case it was the former, she said usually there will be no reasonable grounds to suspect that the officer may have committed the act alleged, save in exceptional circumstances, the example being given being new evidence. And she said that the conduct determination, quote, should be respected and accorded primacy. We say there is no proper basis for those findings, and that the correct position is that where an allegation has been considered and determined in the misconduct regime by a finding of no case to answer, that may be under Regulation 23 of the 2020 conduct regulations, or a finding that no misconduct has been proven, and that could be at half-time in the misconduct hearing, or it could be at the end of the evidence. The question of whether there are reasonable grounds to suspect that the officer may have committed the act alleged requires, as the guidance says, an holistic assessment of all of the information amassed by that stage in the vetting process. That will, of course, require vetting personnel to explore what evidence was available to those who took misconduct decisions. But the vetting process, we say, is not bound nor circumscribed by those misconduct decisions. And in relation to the learned judge's finding of the effect of a no case to answer decision, she may have been influenced, if one looks at paragraph 70 of her judgment, by the case law in the misconduct jurisdiction for case to answer. Paragraph 70 is at page 121 of the core bundle. The threshold for identifying a case to answer is a low one, as if there is a case to answer on one legitimate construction of the facts, the investigator has to recommend that there is a case to answer, and by parity of reasoning, the appropriate authority would have to apply the same test. And I mentioned earlier that this is a much lower threshold than the evidential sufficiency threshold applied by the Crown Prosecution Service. Our point is that the threshold for a case to answer in misconduct, whilst low, it is still higher than the lower threshold of reasonable grounds to suspect.
Is the test for whether there's a case to answer in disciplinary proceedings whether at the end of the evidence the conclusion could reasonably be that a charge has been proved on the balance of probabilities?
My Lord, at the stage where the appropriate authority under Regulation 23 determines whether to refer it to a hearing, the test is if on one legitimate construction there is a case to answer, then they must refer it. The short answer to your question is yes, could. But that's different, of course, from realistically would. So it is a low threshold, but it's not as low as reasonable grounds to suspect.
Yeah, that's the fundamental submission.
That's my first point of...
Your fundamental submission is that reasonable grounds to suspect is not the same as either that something has been proved on a balance of probabilities, or even that there is a case to answer.
No, quite so. It's lower still, because it's at the beginning of the spectrum of evidence that eventually gets to a prima facie case, and a case that then has to be answered, and a case that the panel eventually adjudicates upon. It's right at the beginning of that spectrum. It's not devoid of any objectivity. There has to. It's not fanciful allegations are not going
Certainly
to.
not. I mean, the law, right across the spectrum of the law, it uses that formula.
It does.
For example, to test the lawfulness of an arrest, or
That's
a
the
search,
most ubiquitous example.
or a search.
Yes.
And prima facie, you commit a trespass to the person or a trespass to goods or land if you don't have reasonable grounds to suspect, for example. So it is a rigorous test, it is an objective test, but your fundamental submission is simply, it's not the same as the test of whether something's been proved or there is a case to answer.
Quite so.
Doesn't the tension that we're exploring here arise because of the order of play that you're advocating? Reasonable grounds for suspicion is right at the beginning. It's when you're looking at an arrest or laying right at the beginning, but you're asking us and saying the right order of play is to apply that a very early stage test, to at a stage when there have been proceedings. That's the tension that arises here. The vetting test, and that's why, again, I understand your position, but I just do still struggle with the interplay that you're advocating and the interplay that the 25 regulations seem to adopt, because vetting is it's aimed at a different target, overlapping purposes, I understand that, but the vetting test just does emphasise, in my mind, that it is this early stage consideration, not a test that you can neatly apply to a post-conduct, post-trial situation.
Might only know that I hope I've now made more clear than I ham-fistedly did when you first asked me the question, that by reference to the Home Office guidance, the APP and the code, it's clear that temporal primacy is given to the conduct regime. That's clear. But it's equally clear that when the conduct regime has run its course, a vetting review is mandated, whatever the outcome short of dismissal, even if there was no case to answer at the Regulation 23 stage. And the second reason we say that the learned judge below was wrong in 170 is because the case to answer decision, even to that low threshold, as she indicated at paragraph 70, not 170, is based, as I've said before, on admissible evidence. And the evidence considered in a vetting review will often be different, including intelligence, previous similar allegations from unconnected complainants, pausing there. The fact that they're unconnected may well of itself be cogent, because it begs the question, well, why would different people who don't know each other say much the same things? Or, for example, not infrequently, the accounts sometimes reduced to formal MG11s, oftentimes not, of witnesses who thereafter refuse to cooperate, don't turn up at the hearing, and so forth. And the circumstances which admit of a vetting review are much wider than the only example given by Mrs. Justice Lang of significant new evidence. The evidence to which I've just alluded, intelligence, unconnected complainants, and so forth, may already be there. It's not new evidence, it's just not admissible in the conduct regime. I've already, I think, made the point that perhaps I haven't. The third point as to why...
Forgive me, before you leave admissibility, and please don't say anything in response to this question which you can't. I say that carefully.
Yes.
I recall from my reading of legislation, I think it's now in the Investigatory Powers Act 2016, that there's long been a provision in this country that the product of intelligence the product of an intercept warrant cannot be used in evidence. Now, that's certainly true in a court. Would that prevent it being used in police disciplinary proceedings?
Well, that particular example, my lord, I would tolerably confidently assert the answer to your question is yes, it would preclude it because it would be unlawful to do so.
Yeah, exactly. Let's just assume, and we can be corrected on this if I've misremembered, but let's just assume that there is some evidence. I'm not commenting on this case at all, but let's suppose in principle that there is evidence which cannot be deployed in disciplinary proceedings because legislation prohibits it. Is part of your submission that that's the kind of evidence that could properly be taken into account at the vetting stage?
Well, I will be equally careful, and may I indicate that the intercept product would not be an example of that,
Right.
because that is absolutely prohibited, as your memory correctly.
Oh, even in a vetting exercise?
Well, I would think so.
All right,
Let
okay.
me take
That's fine.
let me take counsel of that.
That's fine. That's fine.
But much more frequently, because dealing with the real world that we face, those of us that practice in this area, much more frequently will be fragmentary intelligence from different sources, some whose reliability it's impossible to assess, for example, a confidential hotline where it's anonymized, some where it may be possible to conduct sophisticated analysis of what is likely to be potentially true and what is unlikely to be potentially true. But our point is the distinction between the misconduct panel's duties to apply the rules of admissibility and the vetting authority's duties is a significant one that perhaps was blurred or overlooked sufficiently by the learned first instance judge. The third point we wish to make, again, an obvious one, is that the threshold for finding misconduct or gross misconduct at a misconduct hearing or meeting is the balance of probabilities. For the court's note, that's regulation 4116A of the conduct regulations. That is, again, indisputably a higher threshold than reasonable grounds to suspect. This may be a variation on my second point, but the basis upon which a finding is made at misconduct proceeding is via evidence admitted in those proceedings. The evidence considered in a vetting review may well be different and more expansive for the reasons I've already given. Our fifth point is that stage 2 of the vetting test involves consideration of the strength of the evidence as part of the proportionality process. And that's why one shouldn't impose, as the learned judge wrongly did, we say, the artificially high hurdle before stage 1 can be cleared. And one sees some expression of that in the decision of Mr. Justice Fordham in the Quirk and Avon and Somerset case. Tab 16 of the authorities bundle, and where helpfully Mr. Justice Fordham set out the factors required in an assessment under Part 2 of the test at paragraph 6. And he was quoting paragraph 8.8.1 of the 2021 APP, but the 2025 variant is to similar effect. If anything, it's even more granular in the guidance that it affords. But he noted that the assessment will include consideration of the number of allegations, the severity of the allegations, the credibility, including whether there is irrefutable evidence to show they are false or malicious, the reasons for matters not being progressed, for example, reluctance on the part of complainants, illness on the part of complainants, and so forth, the amount of time that's passed since the matters in consideration, the age of the subject at material time.
Well, this is just quoting from APP
It is.
2.8.2. Yes.
It is, my lady, and he said in his list of the common ground between Mr. Bamber and counsel for the constabulary, first, that some of the 6 factors can inform stage 1. Secondly, irrefutable evidence to show that an allegation is false would be a conclusive basis for deciding at stage 1 there are no reasonable grounds for suspicion. Thirdly, that where stage 1 reasonable grounds for suspicion are found, the 6 factors are considerations informing stage 2 appropriateness. And our 6th point as to why the learned judge was wrong in paragraph 170, and in fact the court tested me on this, is that her legal test and the high threshold of exceptionality that she applied is, we say respectfully, inconsistent with the triggers in the APP requiring a vetting review on receipt of adverse information or misconduct proceedings that don't result in dismissal. And such a review would be pointless if it couldn't potentially result in vetting being withdrawn. And we say that was exactly what Mr. Justice Eyre found in the Victor decision at tab 15 of your authorities bundle at paragraph 91. And if I just pick it up, if I may please, at 469, page 469, just after letter C, in particular, it cannot prevail against the fact that the requirement that there was to be a review of the claimant's vetting clearance is strongly indicative that this was to be a full and not an attenuated review. So this was a situation where the probationer was found guilty of misconduct and she had a final written warning imposed. The claimant did not go as far as to say that there should not be a review, but her case amounts to saying that the only lawful outcome of such a review in these circumstances would be for her recruitment vetting clearance to remain in place. That would render the review a pointless exercise in circumstances such as those of the claimant, and indeed in most cases where the constable in question does not have an enhanced vetting clearance.
Sorry, I've lost the paragraph. Which paragraph are you?
I'm sorry, it's paragraph 91, and for concision I tried to pick it up just under letter C.
Yeah, thank you.
And if I can pick it up just by way of repetition at D, that would render the review a pointless exercise in circumstances such as the claimant's, and most cases where the constable in question doesn't have an enhanced vetting clearance. He meant where the constable has only recruitment vetting, being the lowest level required. The APP requires the review to be undertaken whenever misconduct proceedings result in a written warning or final written warning. If the claimant's position is correct, that means the APP requires an exercise to be undertaken in all such cases, even though in very many of them the exercise will be pointless. Although Mrs. Justice Lang sought to distinguish Victor on its fact, she didn't doubt the correctness of that proposition, and if it is correct, which we say respectfully it is, then it's inconsistent with her finding that the misconduct proceeding should be accorded primacy, because Mrs. Justice Eyre was expressly finding that the review should be a full not an attenuated review bound by the misconduct outcome. Our seventh point I have dealt with, but I should replay it onto the record, that paragraph 170 ignores the crucial differences between the misconduct regime and the vetting regime. Misconduct proceedings under the 2020 regulations involve a narrowly defined allegation of misconduct said to breach a standard to the civil standard of proof against admissible evidence. By contrast, the vetting review process is multifactorially assessing the risk posed by the officer arising from matters under consideration potentially much broader than a single or several allegations of precise misconduct. It is to the standard of reasonable grounds for suspicion, and it's against the backdrop of material which may not be admissible in the misconduct proceedings. We haven't looked at it, even though it is the basis for the modern police vetting test, but it was, as he then was, Mr. Justice Coulson in A against the Chief Constable of C, that the vetting test was developed, and Mr. Justice Coulson, as he then was, drew on the test in other areas, most particularly control orders and enhanced criminal record certificates. For the court's note, that's paragraphs 26 and 30 of his judgment. In that case, the first stage of the test for reasonable grounds for suspicion was based on the test for control orders under Section 2.1 of the Prevention of Terrorism Act 2005. So what I was proposing to do, hopefully briefly, is go through some questions about the reasonable grounds for suspicion test.
Well, we have been responsible for delaying your journey thus far, Mr. Beggs. But have you discussed with Mr. Rathmell how long he needs? Because I do think Mr. Bamber needs to be on his feet at no later than 2 o'clock.
Yes, I respectfully agree and will ensure that I do that. Where necessary, I will simply give references and move on. Could I invite the court's attention to the MB decision at Authorities Bundle page.
And what are we getting from these decisions now?
You're getting some assistance from other jurisdictions in relation to reasonable grounds to suspect, and this is a decision of the Chief Justice, Lord Phillips, in a control order case. It's 67 that, at page 184, to which I briefly draw your attention, at picking it up just below letter C, the Prevention of Terrorism Act authorises the imposition of obligations where there are reasonable grounds for suspicion. The issue that has to be scrutinised by the court is whether there are reasonable grounds for suspicion. That exercise may involve considering a matrix of alleged facts, some of which are clear beyond reasonable doubt. In this case, for example, having sex in a public place, some of which can be established on balance of probability, and some of which are based on no more than circumstances giving rise to suspicion. So an example of that might be the multiplicity of allegations from female workplace colleagues. The court has to consider whether this matrix amounts to reasonable grounds for suspicion, and this exercise differs from that of deciding whether a fact has been established according to a specified standard of proof. It is the procedure for determining whether reasonable grounds for suspicion exists that has to be fair if Article 6 is to be satisfied.
And do we just need to remind ourselves of what the Lord Chief Justice said at paragraph 59, 2 pages earlier?
My Lord, yes, and this is, in fact, it was sidebarred and I didn't go to it in haste. presupposes the existence of facts or information which would satisfy an objective observer that
That's the basis of your concession before the judge below.
Yes. And a similar, the theme was picked up more recently in the parole board case of Pierce, and perhaps I can, for concision, simply invite the court's attention to the analysis by Lords Hodge and Hughes from paragraphs 31 to 64 in considerable detail, summating at paragraph 65 and at 65.4 on the top of page 432, in the assessment of risk of future behaviour and inherently imprecise exercise, it's not necessary to consider each allegation of past behaviour individually and decide whether it's established on the balanced probabilities. Depending upon the legal context, the court can assess risk by weighing up the possibility that an allegation or several allegations may be true, having regard to all of the material. May I deal with the proposition that the threshold for reasonable grounds for suspicion is low? I think that's already been discussed in debate, but one gets that from the extremely exacting analysis by, as he then was, Mr. Justice Stuart Smith in the Parker and Chief Constable of Essex case. I'll simply give you the paragraph references. It's paragraph 6 to 38, but in particular 31 to 33. And in the appellate decision of the same case, there was no suggestion that Mr. Justice Stuart Smith, as then was, analysis was in error, and perhaps in particular the court could keep in mind paragraph 115 of that decision, the appellate decision, and that's at Authorities Bundle 363. We need to make the point that whilst the stage 1 threshold is low, reasonable grounds for suspicion, protection is afforded to the vetting subject because the credibility and the reliability of the allegation remains in issue at stage 2. So one could get a situation where there are reasonable grounds to suspect various matters, but the weakness of the evidence, maybe its antiquity, maybe its lack of pattern and so forth, would make it disproportionate to withdraw.
Do you accept that when it says not appropriate to withdraw, that embraces a proportionality test?
Yes.
Thank you.
The next short proposition, which one derives from Mr. Justice Coulson in the A decision at Authorities Bundle 279 at paragraph 29, is that even intelligence without more is capable of giving rise to reasonable grounds to suspect. And that, of course, is obvious because many arrests are formulated on intelligence which found grounds to suspicion objectively, but which may, unfortunately, transpire to have been unfounded. The next point is the fact that a matter has been considered against tests applied in another investigation or proceeding, such as here misconduct, does not remove it from consideration at stage 1. This was made clear, we say, by the Supreme Court in the R decision, the Enhanced Criminal Records case, and we invite attention to paragraph 74 at page 393 of the Authorities Bundle, the decision of Lord Carnworth. Given that Parliament has clearly authorised the inclusion in enhanced criminal record certificates of soft information, including disputed allegations, may be no logical reason to exclude information about serious allegations of criminal conduct merely because a prosecution has not been pursued or has failed. In principle, even acquittal by a criminal court following a full trial can be said to imply no more than that the charge has not been proved beyond reasonable doubt. In principle, it leaves open the possibility that the allegation was true and the risks associated with that. And we observe that obviously this applies with equal force to acquittals in the misconduct jurisdiction. And so what we say is that the decision maker in the vetting context at stage 1 should consider any material which bears on the reason for their decision, which may include not bringing misconduct proceedings, or it may include failed misconduct proceedings. And in the same judgment, I don't take you to it now, but there is useful discussion at paragraph 68. That's the same ECRC case. Of course, we acknowledge, as is obvious, that irrefutable evidence showing that an allegation is false would be conclusive on any particular fact that there were no reasonable grounds for suspicion. Our next observation is that the reasonable grounds for suspicion test doesn't necessarily apply to everything at stage 1, because there may be some matters which show more of a propensity rather than a discrete fact or issue. And one might see that in this case, where it appears to be a significant number of similar allegations made by different female workplace colleagues. That might be said to go more to the propensity issue, and it might be said to constitute reasonable grounds to suspect that there are risks associated with this officer. If an officer is, if there are reasonable grounds to suspect that he's misbehaving towards his workplace colleagues, one then is entitled to consider whether that might play out even less attractively with vulnerable members of the public. And one sees some examples of that just for the court's note at paragraphs 22 and 23 of the learned judge's recitation of the facts below. By the time one gets to the second stage of the test, there one is entirely dealing with assessment of risk, and I've already read the joint judgment of Lords Hodge and Hughes at 65.4, and so I won't repeat that, other than to invite the court's attention also to paragraph 87 in that judgment.
Which, sorry, which I've...
That's R.
R again, are we?
No, my fault. It's the Pierce, the parole board
Pierce.
judgment, and at paragraph 87, the court, the judgment went through a discussed risk assessment, and at point 7 on page 440, the board, having regard to public safety, must take into account the allegation or allegations and give it or them such weight as it considers appropriate in a holistic assessment of all the information before it, where it is concerned that there's a serious possibility the allegations may be true. The board must proceed with considerable caution because of the consequences for the decision on the prisoner. Procedural fairness requires to give the board to give the prisoner the opportunity to make submissions. And we say that useful guidance that can be applied by vetting personnel...
I think we can also note the final sentence of that paragraph. It's subject to public law constraints of rationality.
Precisely. And, my lord, that was to be my next point, is that the fail-safe for any subject of a vetting assessment has that ultimate remedy if the internal appeal and the external, more independent appeal to the Police Appeals Tribunal were to fail. This is not a recipe for vetting assessments which are irrational or fail to have regard in a granular fashion to the evidence. The final authority to which we invite attention, but again I'll do so in an attenuated form, is the U3 decision, deprivation of citizenship case, and in particular paragraph 87 of that decision. We have sidebarred 54 to 62, which we say provides useful analysis of how one conducts risk assessments where there is fragmentary intelligence. My Lord, I think in the light of the timing factors, I've hopefully made the points that are consistent with our skeleton and which advance our case. I'll reserve the right to reply if I've missed anything that Mr. Bamber. Unless I can assist, for the moment, those are our submissions.
No, thank you very much indeed. And we should record, perhaps peacefully at this stage, that we found the written submissions of all parties extremely clear and helpful. So thank you for those as well as your clear oral submissions, Mr. Beggs. Mr. Berry, Ms. Hampshire, do you follow? Anything you'd like to add?
Lady, may I just follow on my Lord Justice Singh's question? Intercept product is exactly what would be considered in vetting only. It's something that could not be considered under the police conduct regulations, and therefore if a serious concern about an officer's conduct were founded only on the product of intercept, that could not be disclosed to the officer in misconduct proceedings and could therefore only be dealt with under the vetting regime. And there are other examples that aren't as extreme as intercept product. There could be information from a covert human intelligence source to whom there would be significant risk if their existence were disclosed to the officer. So those matters could only be considered under the police vetting regime. There are, of course, ancillary issues which I gather are being worked through by the Home Office as to whether there might be a requirement for closed material procedures, special advocates, etc., which are not currently provided for in the police vetting regulations. But there are very clearly examples of matters such as intercept, such as covert human intelligence sources that could not be disclosed to the officer, couldn't find life in misconduct proceedings, and therefore to protect the public from the risk posed by that officer could only be dealt with in the vetting regime.
Any follow-on, Robin?
Does that answer my Lord's question?
Yes, thank you.
Thank you. Ms. Hampshire, no. Thank you. Yes, Mr. Rathwell.
Thank you, my ladies and my lord. I've hopefully less than 30 minutes.
30 minutes.
Yes.
Well, we're going to stop at 1 o'clock. So work your way around that, Mr. Rathwell, I'm afraid.
I will do. If I can endeavour to insist briefly with 4 matters that arise from questioning. Firstly, my Lady Justice Whipple's query in respect to the definition of a conduct matter. Going back one step, the Police Reform Act, section 12(2), not in the bundle, but is the source of the definition of conduct matter. That refers to disciplinary proceedings, and within the conduct regulations which you do have, you have the definition of misconduct, and gross misconduct being a breach of the standards of professional behaviour.
Mr. Rathwell, the acoustics are not great in here, so if you could stand closer to a mic or move forward if necessary, but let's see if that's better. Can you hear, Ravinda? You can hear.
Do I need to repeat any of the...
No, we've
we've
so
got
far,
it.
thank you.
But louder would be very helpful, way over this side of the enormous court.
Secondly, and with perhaps a little more time required, the Lady Chief Justice asked about paragraph 171 of the judgment below. college's position may be slightly different from that stated by Mr. Beggs. Conceptually, paragraph 171, not necessary, therefore in principle wrong, and it may mean, in terms of the interplay between the conduct regulations followed by vetting regulations, more time and duplication, although some mitigation is that the conduct regulations provide for an accelerated procedure in what, for present purposes, I'll describe as obvious cases. I gather the foundation for paragraph 171 was the High Court's analysis that vetting decisions should not contradict or frustrate conduct regulation decisions, which conduct regulations decisions had a legislative framework that was, in the Court's analysis, Article 6 compliant, whereas vetting decisions didn't. So 170, 171 do support each other, and they support the overall analysis that the vetting approach of the Metropolitan Police and the college's guidance risk frustrating the conduct regulations. The college's position below and in this court is that vetting decisions and conduct decisions are conceptually different. Vetting is a separate type of decision engaging the public interest in different ways. However, the position now is that the regulations, following consideration and consultation, promulgated a temporal priority with a safeguard of suspension in both the vetting and conduct regulations. And if I can assist briefly with the background to that, the police conduct regulations might be thought to have wider or more significant consequences for an individual than the vetting regulations. So conduct regulations dismissal, you go on to the public statutory barred list from the Police Act, the public-facing barred list, and there's a usually published decision with findings and sanction, or if there's no sanction, simply findings, and allegations of breach. And the conduct regulations involve more powers of investigation, and the practical benefit, putting aside the conceptual issues, the practical benefit of the conduct regulations going first is that they generate relevant information. And if an officer is dismissed and barred from any law enforcement role nationally, then no question of vetting is going to arise. A concern, principally by, I think advanced by Mr. Baumber's clients, about the potential for vetting to undermine the conduct regulations was that the stigma and rhetoric of misconduct, breach of standards of professional behaviour sometimes found voice in vetting decisions, and vetting might have been thought to be an easier, swifter route to dismissal, and that's obviously what individual officers were concerned about. The third matter I wanted to assist you with at the outset was my Lord Justice Singh's reference to the supplementary bundle, page 209. And just for clarity as to the college's position, paragraph 7.34, the reference to primacy, is intended as temporal primacy, and that's supported, not substantive primacy, and that's supported by the paragraph above and below, which encourages engagement with the substance of matters not proven in the conduct regulations. And it's also clear in new and improved terms in the Home Office vetting guidance in the supplementary bundle 251, paragraph 1.47, sorry. That's the Home Office guidance, which states that forces must give appropriate regard to the outcome of other proceedings However, any outcomes which state that the matter being considered is unproven or the officers not guilty, I skipped some words, do not preclude forces from assessing whether the officer remains suitable. So the current position of the parties as to primacy is clear, I hope. The fourth point is to agree with Mr. Berry's reference to the way that sensitive intelligence may have to be dealt with under vetting provisions rather than conduct provisions. Agreeing with him and referring to the Investigatory Powers Act, sections 56 to 59. And my skeleton argument at paragraph 19b, the provisions I've just referred to being the clearest example of the issue I raise at 19b. To my substantive submissions, again, as briefly as I can, paragraph 170 of the judgment below states and applies a general principle which, with respect, is a wrong statement of principle, by which I mean reflecting legal error or a flaw in logic. And I do mean with respect, because you'll note the scope and precision and speed of the judgment below, and also that the learned judge was right to grip the issue in paragraph 170 of what should be done in the vetting context with acquittal information, if I can use that shorthand. You will see in the GMC Greater Manchester Police case in tab 13 of the bundle, the Supreme Court noted in a couple of places, but for your note, it's tab 13, paragraphs 30 and the postscript, the absence of guidance in a particular evolution of the enhanced criminal record certificate scheme about what to do with acquittal information. That absence of guidance was, I submit, not a problem in the policing context, because the colleges Authorised Professional Practice, APP 2021, did have a section dealing fairly with acquittal information, paragraphs 8.8, and Mr. Beggs went there, so I'll be brief, but 8.8 and 8.38 was the sort of guidance once absent from the Enhanced Criminal Record Certificate Scheme about what to do with acquittal information. Consider on a case-by-case basis. I'm sorry, this is supplementary bundle 129. That's the 2021 APP, provided useful guidance to vetting decision makers as to what to do with unproven allegations. Both pages 129 and 130. A difficulty with paragraph 170 of the judgment below is the uncertainty it causes, not a criticism of the judge, but the uncertainty it may cause now, because the vetting regulations and the new Home Office guidance might be thought inconsistent with 170. I think that's because they permit expressly vetting decision makers are not prevented from considering unproven matters. And the guidance I referred to a few moments ago, the fact that an officer is found not guilty does not preclude forces from assessing. But a further uncertainty that may rise from paragraph 170 is when the learned judge used the word disregarded, what in particular should be disregarded. Is it the allegation or the fact of the allegation, or is it the file dealing with that allegation and all the evidence that was assembled to deal with it? Conduct regulations, right from the start, regulation 4, that's concerned with allegations, whereas vetting decisions are concerned with information. So the learned judge, third last line of 170, therefore, those allegations should be disregarded. She's stated the principle in applying it, but there might be significant relevant information in the conduct file dealing with those allegations, highly relevant to the vetting decisions. In relation to error of principle in paragraph 170, I think Mr. Beggs referred to 7 errors or reasons. If I can give an overview of 2. First, which I think the court has, is that it equates, paragraph 170 equates the opinion given under the conduct regulations in regulations 21 and 23, the opinion of no case to answer, and also equates a finding in conduct proceedings of not proved, equates those things with the absence of reasonable grounds of suspicion, which is wrong because conduct regulations decisions are, at all the important latter stages, including the case to answer test, addressing a particular standard of proof, what is more likely than not. And they address a binary question, not risk analysis. Mr. Beggs referred you to the Parker decision, including the Court of Appeal decision, Authorities Bundle 363, and he referred to paragraph 115. May I also recommend paragraph 116, because always with analysis of what is the standard of reasonable grounds of suspicion, one finds references to something like the first half of this paragraph. Very learned counsel, of course, for the claimant in that case, fell into the trap, the court said, of focusing on particular information or allegations piece by piece, the trap of over-compartmentalisation, and ignored the cumulative effect of the material obtained in various allegations. So that's support for the multifactorial, all circumstances approach of vetting. Another reason why the reasonable grounds of suspicion test is fundamentally different from the more likely than not standard, even for a case to answer decision, but all the more obviously so for a not proven decision in conduct proceedings. The second error with respect in paragraph 170 conceptually is that it outsources the vetting decision to the conduct regulations decision makers. So the conduct regulations, again, concerned with particular allegations, whereas the vetting regulations concerned with information and risk. It's wrong for a vetting decision maker to focus on the result in conduct proceedings. He or she must instead focus on information, perhaps generated by those proceedings, and it works both ways. If a vetting decision maker made a decision in effect, well, the Crown Prosecution Service thought that there was enough information to charge, therefore I have reasonable grounds of suspicion and will recommend a withdrawal of vetting. That would likely be an error. It may not vitiate the entire decision, but that's not the sort of reasoning that courts would endorse in the administrative courts. So an error is that it requires a vetting decision maker to, in effect, defer to the decision of a conduct regulations decision maker. And the suggestion in paragraph 170 that relevant matters should be disregarded runs 3 interrelated risks. First, that incorrect decisions in the conduct regulations would have to, in principle, be replicated. Instead of there being the check and balance of two separate streams. Secondly, accountability would be undermined because the vetting decision maker would say, in effect, if something went wrong in the future, that it was not their decision. They were required by paragraph 170 to substantively defer to the conduct regulations. And third, public confidence would be undermined. The principle should be that anything relevant to risk analysis should be taken into account in a vetting decision, even if, in the end, it does not lead to the withdrawal or the decline of vetting. And this court should, with respect, be cautious of any principle or gloss which suggests that relevant information should be disregarded because of some technical interplay between provisions or types of decisions.
Now, I'm going to have to stop you there. I'm afraid at least one of us has commitments over the short adjournment. Mr. Baumber, forgive me if I mispronounced your surname. How long do you think you will need in submission?
Less than 2 hours, my lady.
Less than 2 hours?
Yes.
If we give Mr. Rathmell 10 minutes at 2 o'clock,
I'm very happy with that.
will that
Thank
be
you,
all
my
right
lady.
for you?
Absolutely,
Are
yes.
you sure? Okay, well, 10 minutes, Mr. Rathmell, if you need them.
Thank you, Madam.
Just found your submissions extremely helpful. You don't need to repeat anything or go over the same ground that Mr. Beggs has, obviously. So any fresh points, no more than 10 minutes at 2 o'clock. Thank you very much.